OK, reflections on the BHA hearing involving jockey Robbie Dunn very shortly. Of course, that still has quite a long way to play out because it's only the prosecution case that rests. The High Court has heard the case against Graham Gibbons brought forward by Freddy Tylicki on account of Gibbons' alleged negligence in a race at Kempton that led to Tylicki's fall in 2016, that led to him being paralysed from the waist down. Chris Cook has been in the High Court this week. What, Chris, has been, I would imagine, quite an upsetting case to follow in every respect.
Yeah, that's absolutely right, of course, because of the consequences. I think one of the first things that Ryan Moore said when he took the witness stand as an expert witness called by Freddy Tylicki's legal team was that he obviously feels tremendous sympathy for Freddy in the situation that he's been left in. But he did also say, he feels a lot of sympathy for Graham Gibbons, who's having the blame sort of directed at him. I think Ryan said something like it's a wretched situation for everybody. And, anyone could agree. The first day's evidence, Freddy was subjected to cross-examination at some length by the barrister appearing on behalf of Graham Gibbons, which involved seemingly endless replays of the race, in particular the moment where Freddy's injuries were sustained. It was a lot to have to sit through. And, at the very end of it, the judge made a point of thanking Freddy for being so patient and for putting up with watching it again and again and asking probing questions about the moments before the fall and the injury. That was actually quite sort of an emotional moment, I think, for a lot of people in the courtroom. That she acknowledged that, and that he stood up to it so well.
What was the most striking piece of evidence that you heard this week?
I don't know if I care to pick out one. There were a lot of sort of dramatic moments. I mean, you'll know yourself perhaps that when you're in court for a whole week, there's tremendous long hours. It's a bit like what your man said about war. It's long periods of boredom punctuated by moments of, intense excitement. Excitement probably the wrong word, but there were moments of intense drama certainly this week. Including when the credentials of people that we know very well, like Ryan Moore and Jim McGrath, their credentials to be expert witnesses were called into question. We had Jim Crowley saying that he could smell alcohol in the breath of Graham Gibbons on the day in question, which was obviously countered by the defence. Graham questioning whether that could possibly be true. I gather there's another jockey been on Twitter this week who was not called as a witness, saying that he was there that day and did not smell any such thing. The Freddy Tylicki's legal team don't seem to be sort of making a particular argument that was what led to the collision. I think the expert testimony of Ryan Moore is what guides them, and what he's put in his report is that Graham's actually made a deliberate move to go back to the rail, and that's ended up causing this accident.
I suppose the most crucial part of this case, Chris, is the what if, isn't it? And isn't the defence case chiefly resting on if you find Gibbons negligent, then what does this mean for the sport as a whole? And how is the sport going to operate legally and functionally moving forward?
Yeah, I see a lot of that concern, particularly on social media. I think really one has to acknowledge that duty of care that's being described, that jockeys owe to one another in a race, that has always existed. Even if you go back to the prior case that people remember in this area, when the jockey Peter Caldwell suffered a really serious spinal injury at Hexham in 1994, and he brought a case against Adrian Maguire and Mick Fitzgerald, which ultimately failed. Whilst the Court of Appeal, reinforced that decision, as it were, they didn't say, there can be no circumstances in which a jockey might successfully sue another jockey for negligence leading to injuries. That duty of care, to take reasonable care for everybody else who's in the race, that has always existed. And it will always be a question of the particular facts of each case, whether or not that duty has been breached. Obviously, Freddy's legal team say that there's enough there to conclude that in the circumstances of this case, it was breached. Patrick Lawrence QC, who's a very tremendously effective courtroom barrister, was making a great deal of how this is a dangerous sport in which split-second decisions are always called for. What Graham Gibbons has done, he doesn't think is open to criticism. But he says even if you do find that it is open to some criticism, we're talking about a mere error of judgment, something that really any jockey might have done in the circumstances. Given that this is the first case that's actually reached court for 20 years, I don't know if we really have to worry about any particular floodgates being opened here. The judge who tells us that she's going to produce a verdict sometime in the next 3 weeks, she's going to determine it with regard to the particular facts of this case. It does not mean that whenever there's interference or whenever a jockey is sort of found guilty of careless riding, even if that results in injury, it doesn't automatically mean that jockey is going to be able to sue for damages. I think inevitably there's going to be insurance implications if there's a payout in this case, because from the catastrophic injuries that Freddy suffered, it's going to be a very valuable claim if it does succeed. And yes, that is going to raise potentially practical difficulties for whoever's arranging the insurance for jockeys. It will get more expensive. You might even be in a situation where you're having to persuade an insurer to actually provide that service at all. But that's a practical difficulty that the sport will have to sort of deal with when it happens. I don't think it's remotely fair to say that because things would get difficult for horse racing and we've got a problem to face up to an insurance issue, therefore Freddy's claim should fail when otherwise it would succeed. I don't think that will be any part of the judge's thinking.
That's very interesting. Can the judge award discretionary damages in this case? I.e., does she have to award the entire amount that is being claimed for or not at all? Or can she go at any point on that scale?
Well, so what we've had this week was a hearing specifically on liability. The sum that would have to be paid wasn't really touched upon. And if Judge Karen Walden-Smith rules that in fact the duty of care has not been breached by Graham Gibbons here, and he doesn't owe anything in damages, then that's the end of the matter. If, on the other hand, she rules that there was a breach of the duty of care, then there's going to have to be further legal discussion between the teams. Perhaps they'll be able to agree an amount. That doesn't seem very likely given the sums involved. Probably they'll have to come back for another hearing at some stage, maybe next year, to determine the consequences really and the cost and what would have to be paid to Freddy in compensation. Probably realistically, there would be no rush to determine an amount because the consequences for Freddy of what's happened at Kempton 5 years ago are going to go on and on for years to come. And if you're acting on his behalf, you don't want to rush to some when it might emerge, in the months or years ahead that actually his condition is going to deteriorate. He requires greater care. So that's all for the future. That's all conditional on what the judge rules in relation to the evidence that she's heard this week.
So, Chris, if you were the sports regulator, if you were running the BHA and watching the Gibbons-Tylicki case, what would you be thinking now? What themes would have struck you as those to zone in on, irrespective of the outcome?
Well, I think there is an issue in terms of what jockeys say to stewards' inquiries. That came up because Pat Cosgrave obviously gave evidence to the original inquiry to the effect that I think Freddy Tylicki had been a bit ambitious in taking the run that he did, and then called to the High Court this week and giving evidence and oath. He said he gave evidence that wasn't at 180 degrees from that. It was it was nuanced, but it was different. He said, as Jim Crowley also said when he was giving his evidence, the footage itself speaks. Freddy's horse would not have been able to get as far forward as he did next to Graham Gibbons' horse if there'd never been room there at any stage. And when Pat was asked about, why are you saying something different to what you said to the steward's inquiry, the answer was, well, there's a code of conduct among jockeys to stay neutral. It wasn't something particularly involved me. It's for the stewards to determine if anybody's at fault. So the judge put it to him, is this a code of conduct to not get other people into trouble? And Pat didn't go as far as that. He said, that's not quite the case, but I was trying to say, as it were, stay neutral. Now, the steward's inquiry is particularly important in this case because the stewards on the day ruled that it was accidental interference. They didn't find anyone at fault for what had happened. And if Freddie's legal team are going to succeed, that's like a hurdle that they have to overcome. You're asking a judge who has, we believe, no prior experience of horse racing to rule that those very experienced stewards on the day got it completely wrong when they said it was an accident. You asked about the BHA sort of taking lessons from this case. I think if you put this together with what's been said in the Bryony Frost hearing, there is a bit of a cultural issue, I think, in relation to the weighing room and jockeys' frankness with stewards that is going to have to be addressed. There's just sort of a disconnect there. Even when Charlie Lane, who was the expert for the defence, and as a steward of some 30 years standing, when he was giving evidence, he was clear that stewards could not always expect frankness from jockeys. And that's a real issue for the regulator of the sport going forward. We have to get ourselves to a better position, I think, where stewards can sort of rely on the evidence that they're hearing.
Have you got any ideas for them in that respect?
Well, that's a 5-hour conversation, isn't it? Not off the,
I know you well enough. You can do this in a minute or two.
No, look, you have to begin by, I think, sitting down with the PGA and addressing this and saying, well, look, clearly, despite all of these years of working together, we're not on the same page. What can we do that's going to improve the situation, that's going to allow our stewards to accept and understand that jockeys are speaking plainly to them. And it may be that the jockeys themselves have to have a conversation about the present system isn't working perfectly for all of us in here. How can we how can we get to a better place where stewards are making the right decisions and we can have full confidence about that?
Chris, I know it's been a very difficult week for everyone who's been sitting through this case. I appreciate your time and thank you for making it, digestible for us and explaining exactly what the implications are.
It's my pleasure, and I guess we'll be back in about 3 weeks to discuss what's been said. But I should say, whenever we get the judgment, it's probably not going to be the end of the story. I think the Caldwell-Maguire case, that ended up in the Court of Appeal, and there's every chance that whatever is decided at first instance, as it were, this might very well be a judgment that ends up getting appealed by either side. So it could be that we go on having these discussions for some time.
Thank you, Chris. Subscribe to Racing TV to be notified when more Luck on Sunday videos are appearing online. And don't forget to join me for the show every Sunday morning from 9 o'clock with the best guests.